Let's take a look at another kind of property hypothetical. And if you're getting ready for the bar exam, then I would again suggest that you do this using your final outline for the subject. And hopefully your final outline, if it's computer printed, is no more than, I don't know, 5 or 10 pages. You certainly don't want a 40 or 50 page final outline. Your final outline should contain only the major topics that you really need to memorize, the major topics and rules, and it should be organized so that it's in issue clusters that normally go together. As you work through the hypothetical, look to whether your final outline is helping you or whether it needs to be reorganized. So what do we have here? What interests, if any, does Baker have in Whiteacre? If you were on the bar, that would have told you immediately that this is property. Second call, what interests, if any, does Bank have in Whiteacre? And the third call, what claims, if any, may Mary assert against Abel? So we've got Baker, Bank, and Mary and Abel. All right, this is going to be a racehorse, and we'll see what subjects are involved. Abel owned Whiteacre in fee simple absolute. Now, if I have time, I'll define fee simple absolute. I'm rather slow at writing answers, so I may not have time. Baker owned Blackacre, an adjacent property. In 1999, Abel gave Baker a valid deed granting him an easement that gave him the right to cross Whiteacre on an established dirt road in order to reach a public highway. Okay, so easements are going to be a big subject in this answer. So I'm going to define the easement. In other words, this is an express grant easement. And if I have to make a choice, I'm going to focus on dealing with discussing the meaning of easements, the kind of easements, of how they were created, rather than discussing fee simple absolute, because easements are at the core of this hypothetical. Why are they telling me on an established dirt road? It looks like the servient estate, which I need to define, is about to be sold, and we need to know whether the new owner is going to be subject to that easement, because it says Baker did not record the deed. So there is no record notice here of that easement. But there are 3 kinds of notice, and anytime I deal with notice, I need to discuss all 3. The dirt road crosses over Whiteacre and extends across Blackacre to Baker's house. Both Baker's house and the dirt road are plainly visible from Whiteacre. All those facts go to inquiry notice. There may not be record notice here, but there may not be actual notice when this is sold. We'll see. Probably not. But there's certainly inquiry notice because that road is clearly visible. And so a reasonable buyer would have seen the road and would have inquired about it and would know about the easement. So I'm expecting a sale coming up in this hypothetical. The next paragraph says, in 2000, Abel conveyed Whiteacre to Mary. Okay, Mary is the buyer of the servient estate. To Mary in fee simple absolute by a valid general warranty deed that contained all the typical covenants but did not mention Baker's easement. So again, here comes the concept of notice. And here we have it. There is no actual notice. Mary is not told about it. But she certainly has inquiry notice. I need to tell the reader what a general warranty deed is. In other words, that it contains 6 covenants, 3 present and 3 future. And I would imagine that's going to go to call 3. What claims, if any, may Mary assert against Abel? Mary paid Abel $15,000 for Whiteacre and recorded her deed. Okay, her deed does not contain any mention of the easement, so there's no record notice for her, and apparently not for any future buyer or lien holder, but there's certainly inquiry notice. $15,000, and the deed has been recorded. Thereafter, Mary borrowed $10,000 from bank and gave bank a note secured by a deed of trust on Whiteacre, naming bank as beneficiary under the deed of trust. Yet another term of art that I need to worry about explaining to the grader. A deed of trust is a security interest. It means that there's a borrower and there's the bank who gave out the loan. The deed is held by a third party, and the bank, if it forecloses, can then force a private sale. Okay, that's what a deed of trust does for you. Bank conducted a title search. Well, we already know the easement isn't mentioned in the title, but did not physically inspect Whiteacre. They're trying to trap unprepared bar candidates into saying that, well, since they didn't look, there's no inquiry notice. But that's not the standard for inquiry notice, is it? It's would a reasonable buyer or reasonable lien holder have seen that road when they inspected the property, when they did a reasonable inspection of the property. So yeah, there's inquiry notice here for bank. Bank recorded its deed of trust. Okay, so we know that Mary recorded, we know that bank recorded the deed of trust, and we know that neither of them is a bona fide purchaser for value without notice because they both had inquiry notice of that easement. Mary defaulted on the loan. Of course she did. In 2001, bank lawfully foreclosed on Whiteacre and had it appraised. The appraiser determined that Whiteacre had a fair market value of $15,000 without Baker's easement and a fair market value of $8,000 with Baker's easement. So that easement decreased the value of the property almost in half, decreased it $7,000. Bank intends to sell Whiteacre, and they can do that in a private sale, so they don't have to get all of their money back, because then they intend to sue Mary for the difference between the sale price and the loan balance. That's what Call 3 is about. Mary asserting claims against Abel because the bank is going after her for the difference between the sale price and the loan balance. All right, I'm okay until now because I'm going through this line by line, methodically, figuring out what the issues are, what do I need to talk about. And so far, yeah, it's a racehorse, but it seems pretty manageable. And then I hit this last paragraph, sentence with a part of a recording statute in it. The following statute is in force in this jurisdiction. Every conveyance or grant that is not recorded is void as against any subsequent good faith purchaser or beneficiary under a deed of trust who provides valuable consideration and whose interest is first duly recorded. Now, if your mind went blank and you just sort of freeze at all of that and think, uh-oh, I can't do this, that's a recording statute. Make it really simple. It has a good faith purchaser, subsequent good faith purchaser, and it has whose interest is first duly recorded. This is a race notice jurisdiction. And you need to know what that means and how to analyze what happens with this. The first bona fide purchaser without notice who records is going to prevail. It's that simple. Now, this whole hypothetical isn't simple, right? Because call 3 means that you then have to know the 6 covenants contained in a general warranty deed, and you need to be able to discuss those in call 3 when you're talking about claims Mary may assert against Abel. 3 present covenants and 3 future covenants. Present covenants are personal to the grantee. Future covenants run with the land. And I'm not going to teach you property law in issue spotting these essays, but that's very basic property law that you should probably already know, and if you don't, any good outline will describe them to you. Now think about it. That's a lot of issues to have to talk about. Okay, we spotted all those issues. Now let's answer the questions. First one, what interests, if any, does Baker have in Whiteacre? Well, the issue here is whether Baker's failure to record means that he lost his easement. Mary bought the servient estate, and this is a race notice jurisdiction. So if Mary is a bona fide purchaser for value without notice, then her recording would extinguish Baker's easement. So the whole issue, or the main issue in the first call, is whether Mary is a bona fide purchaser for value without notice. And we know that she is not, because although she didn't have actual notice or record notice, she was on inquiry notice. So the fact that she was the first to record doesn't extinguish Baker's easement because she was not a BFP without notice. So Baker has his easement. What about what interests, if any, does Bank have in Whiteacre? Call 2. Well, that revolves around the deed of trust, Mary's default. I'm going to discuss all that. And then Bank's interest. Bank recorded. Does that mean that Bank extinguished the easement? No, for the same reason that Mary's recordation did not. Bank was on inquiry notice. Bank is not a BFP without notice. So Bank's interest in that property is worth only what the property is assessed at with the easement. But they can sue Mary for the difference. That's, in essence, the answer to call 2. Call 3, what claims, if any, may Mary assert against Abel? That goes to all 6 covenants in a general warranty deed. And so I would go through and analyze all 6 and discuss Mary's rights against Abel. If this run through, if this issue spotting of this hypothetical and this practice has helped you, then please share it with friends, classmates, fellow bar candidates. Help us spread the word, help us grow the channel.